All right. Okay. Well, good morning. Happy Friday. Happy June. All right. I can't believe summer is upon us already. Jeez. June gloom out there, right? Doesn't feel like it's summer, but we're halfway through the year already. So thank you so much for being on today's contract class. Again, if you don't know who I am, my name is Simon Cazares. I am the team leader and the managing broker for multiple offices. I'm pushing 30 years come 2027. I'll be officially a big 30. So, I'm excited about that. It's a milestone. It's like, God, where did all these years go? I remember being in class and just overwhelmed with so much stuff. And that was back before technology even took us where we're at now. So I definitely appreciate you being here. For me, is always providing value and the most updated information. Now, this is straight from the California Association of Realtors. All I do is just go to CARS website and ultimately pull information. And then I just gather my thoughts and prepare a presentation. And sometimes is I share stories, right? Stories that have transpired within the offices, life scenarios. That's how I learned was scenario based, right? Things that happen through a transaction. It just gives us a better perspective and a better view in how we navigate conversations. With that being said, we're going to go into the notorious Section 8 vouchers and rentals. What every housing provider, and what I mean by housing provider, they change the lingo. We used to call them landlords. Okay, that is out now. It's housing providers. So when you're having conversations with the owners that have rental properties, you reference them as housing providers. Okay, that's the common language moving forward, not landlords. Even though a lot of people still say, "Oh, the landlord," right? Well, that is out of the vocabulary per se. So now we call them housing provider. So a step-by-step compliance guide on California housing property managers and again it says landlords based on 2024, right? So I want to emphasize and stress the importance of how we navigate this, and not necessarily that we're educating you on property management, because one, none of our offices allow our agents to conduct property management for compensation. Okay, the only way that you could do property management for compensation is one, if you're a licensed real estate broker. Two, you have your own DBA that is not attached to Keller Williams. And then three, you have to have your own errors and omissions insurance. Okay. Hold that thought for a minute. um, that's kind of the only avenue that you could. You signed an agreement with Keller Williams that states the fact that you don't do any loans nor property management. And the only reason we don't allow it is that your license does grant you permission to do so. But the problem is a lot of real estate companies don't, because they don't have insurance to cover you, errors and omissions insurance. And if you're caught, handling property management, one, if there's a lawsuit, you're basically responsible if there is any damages, right? Right now, with the state of California, especially here in the Los Angeles, and more so Los Angeles city, it's really tenant protection, right? So how do we maneuver the conversations and all that? And more so, this sensitive topic of section 8, right? So we'll dive deep into the conversation and get you kind of acquainted and how to navigate these situations. All right, so let's go ahead and continue. So the widespread discrimination, okay, and that's really what today's training is, really to arm you with an understanding and how discrimination is so up here, with a lot of cases happening where big companies and even real estate agents are writing checks. Just one little word that you say will alter. And there's attorneys out there right now, as we speak, that are ambulance chasers that are consistently out there chasing opportunities to catch us red-handed or the owners red-handed, so that way they can file a lawsuit. So in 2024, the California Civil Rights Department is the state agency responsible for enforcing fair housing laws, conducting extensive systematic affairs housing tests across California rental market. The results were alarming, right? Discrimination is based on tenant use of housing assistance programs was found to be a widespread situation as directive results from the CRD has filed numerous fair housing cases against housing providers. Private attorneys have independently conducted their own tests and filed at least 40 additional fair housing lawsuits. The legal and the financial exposure is for non-compliant. Okay, so you got to be compliant. You got to treat everyone equally, right? The exposure for non-compliant housing providers is significant and it's growing at a fast pace. Okay, why is this not clicking? So let's continue. Okay, so the legal and financial stakes are super high right now, right? So private lawsuits have filed, okay? And the reason we still don't have the stats for 2025, so this is referencing back in 2024. I can tell you that what you see here has escalated in 2025. And I can tell you that even in 2026, that number is probably going to be even higher. So 40 plus private lawsuits based on independent fair housing tested by private attorneys, damage sought. Many private cases seek up to $100,000. So think about this, right? If you say or put something in writing that alters a person to allow Section 8, then they're going to start really high. It's what we come to an agreement, right? Usually, it's somewhere in the middle. So if you see $100,000 complaint come in, then we're probably going to end up settling anywhere between $30,000 to $50,000. Okay, not good. And the reason is, think of errors and omissions like automobile insurance, right? The more citations you get, the more accidents that you get that it's your fault. What happens to your insurance premium? Increase? Yeah, yeah, because every year prior to renewing our errors and omissions insurance, guess what? We have to provide a list of any claims, any possible, or anything that may be in the near future that may cause a potential lawsuit, right? Where there's monetary damage, right? That's how they base their position of how much they're going to be charging each and every independent real estate brokerage, right? And especially for a large real estate company like Keller Williams, it can be in excess to hundreds of thousands of dollars sometimes, just on fees, because the more agents, the more problems, the more that these errors and omissions insurance companies will have to write off checks, right? We try to minimize that, right? And this is why having a great broker to be able to diffuse, de-escalate the situation is vital. But then we also have what's called risk management, right? Risk management is a layer of protection that protects our errors and omissions insurance because we do not want to ultimately tender our claims to E&O because once that's kind of a ding, like a credit inquiry on your credit report. The more tenders we do, meaning how many times we're reaching out to our errors and omissions, even though there may not be a settlement or any monetary damage, it's still a ding on our errors and omissions. And when we have to renew our license, right, we have to report that. So they base all of that information. This is why we have brokers involved. This is why we have risk management involved, because they tend to help diffuse, de-escalate the situation before we have to ultimately send it to our E&O. So I hope in a nutshell that kind of explains the situation. Okay. source of income, protected. Did you know that income is a protected class, just like handicap is a protected class, right? So what the law says under the California Fair Housing Law, source of income is a legally protected class. Housing providers, meaning the owners of properties, are prohibited from discriminating against any applicant or any tenant who receives assistance from a government program, okay, that provides rental assistance, security deposit assistance, or housing subsidized, such as HUD Section 8 housing choice voucher program, right? So any of these are protected classes. So immediately when you hear I get rental assistance, I have housing Section 8 voucher, or even security deposit assistance, that should be a red flag. Okay. Not that it's wrong, not that it's anything wrong with that, but you got to have those alerts saying, okay, I got to watch what I say and how I conduct myself with a conversation, because they're trying to entrap us, to try to find us to say something illegal that now they can frame you and ultimately put a case against you in the brokerage. Okay. So it's important that all of us educate ourselves and understand the ins and outs and how all this works. Who is protected? The protected parties applies broadly to any person who rents in a whole in the party by a government program, right? Most commonly, holders of HUD Section 8 housing vouchers, applicants and current tenants alike are protected from discrimination at every stage of the housing process, from advertising through tenancy. So again, we as real estate agents, our primary focus is always, buy, sell, and invest, right? But on occasions, people want to rent their places, right? They want to move to a different location, but they don't want to sell their property, and they're asking us as real estate professionals, "Hey, can you help me rent my place?" Right? So the answer is absolutely, right? It's still some income that you receive, not a lot, but some income that you receive when it comes to, property, renting properties in the local area. But that's already a position that you have to have that layer of protection, because you're going to get a lot of people, and a lot of them is not real estate agents. They're calling you as a consumer, inquiring about the property. Okay, so be mindful about that. So, what is a Section 8 housing voucher? So, it's a federal program, local administration. The Section 8 program is funded by HUD. Okay, tenants pay a portion, right? Vouchers hold pay for a portion. So, in a sense, Section 8 is not a bad thing, especially for the tenants that have very low income, right? Maybe don't have a career, doesn't they don't make enough money. It's an assistance to help through the eyes of a housing provider, that people that know and understand, that can be a win-win, because at least it's guaranteed that you're going to get paid your rent each and every month, because it's not the tenant that is paying the blunt of the rent, is the government is paying a big percentage of it, right? So even if they default, which they shouldn't, because that impacts their position to qualify, right? So they're probably the most on time when it comes to their payment, because they look at it from a position of gratitude, right? That I'm getting assistance from the government to allow me to rent a place that unfortunately I may not be able to, right? Because I'm a single mom, I'm a single father, my income is not up there. Maybe I have some issues that I cannot work full time. I have to work part time. So there's many reasons behind the assistance, right? And low income, right, is the biggest one. The program assists low income families, right? So it's a good thing, but it is also something that you have to be cautious in how you navigate it, right? Because even if you get a potential applicant that is with a Section 8 voucher, you still have to provide that to the housing provider. All applications need to go. Okay. So what if this situation happens to you? Okay. And I'm just throwing it out. Okay. That the housing provider says, Simon, I'm allowing you to do and handle my property to find me a qualified tenant. But under no circumstance, okay, I do not want any applicants that are Section 8 or low income. I don't want you to send them to me. What would be your response to the housing provider if that was said to you? Anyone? How
We
would you
cannot
handle that?
we cannot do that.
Okay. Yeah. Unfortunately, you're right. We cannot. So you have to be in a position to be comfortable explaining that to the housing provider because it may be that the housing provider may not know. Okay. And that's common. They may not know. Okay. They may know that they have heard bad stories about Section 8, but they may not know the internal impact that that may cause if they're asking us not to allow someone to apply. Now, remember, understand the situation. We're not saying, right? We're not saying that the application that is a Section 8 will get the property. They still have to go through the initial process. Just like everyone else, you got to treat everyone equally. And it's based on a lot of criterias, right? It could be the income, the credit, how much money they have in their bank accounts for reserves, right? How many people are going to be renting, right? Do they have a history of issues? Have they had in the past an eviction, right? All of that comes into factor before making a final decision and who is going to be the qualifying tenant that's going to get the keys to the property, right? They have to go through a venting process. But you cannot discriminate, ladies and gentlemen, regardless if it's an applicant with very low income or a Section 8 voucher, you treat everyone equally. Does that make sense? Yeah. Okay. What you cannot say in advertisement, right? So, in the discriminatory language and rental advertising, when explicit or implied, it's a violation of California fair housing law and a common trigger for enforcement action. Avoid the following. Okay. So, take a picture of this, or if you want a copy of this presentation, I'll be more than happy to provide you this. At the end of the presentation, there's also a link that will take you to the site where it's Q&A, which I love. It gives you the questions to topics that maybe come across and an answer to those questions. And I highly recommend that all of you take some time, educate yourselves. So, an explicit rejection statement. Never include phrases like no Section 8. Okay. That's a no no. Housing vouchers are not accepted. Okay. Common sense, right? Um, any listing advertisement, flyers, or verbal communication, these statements directly signal discrimination. And 10 and are per se a violation of sort of income protection. Remember, go back to the protective class, right? The income. Income is a protected class, ladies and gentlemen. So if even they make $1 income a month, okay, and I'm exaggerating, and the government is willing to pay $2,500, okay, that person is still protected. Well, Simon, it's only $1 to make, I get it. But remember, the income is coming from a resource that may be a city, maybe a county, or it may be the state, okay, that is helping the consumer. Implied rejection statements avoid language that implies voucher holders would not qualify. For example, for professionals only, executives preferred, okay, or other coded phrases that signal a preference for applications without government assistance. Remember, anything that you can avoid, right, um, that will get you into an entrapment, that's what we're trying to educate. Yes.
this makes me think about a situation where I was looking at an apartment for someone.
Yeah.
The qualifications were they had to have income 3 times the rent.
Okay.
That excludes the Section 8.
Yeah. So you got to be very mindful and careful. And this is why researching and researching is vital and important. Now, the question is because there is a layer of qualifications, right? Because remember, pros and cons. Are they looking for a property that, the rent is $10,000 a month, right? So you got to weigh it out as well, right? As you're navigating the conversation. Now, if it's a property that is 1,800, it may fall under that class protection income, right? You would have to be able to justify that position as, and if you feel that there is some type of discrimination, then you as a real estate agent have the right to also help file a complaint or have the tenant that you represent file a complaint with the appropriate agency. Okay. Because we got to stop people that either are ignorant, don't know, or discriminating, because there's people out there, unfortunately. So, good point. The right answer to do is we accept all Section 8. If an applicant asks whether you accept Section 8 vouchers, always respond, we are a fair housing provider and all qualified applicants are welcome. The key here is all qualified applicants. Doesn't mean that that client will qualify, but we are stating the fact that all applicants that qualify shall be able to apply. Make sense? All right, so let's see, 1 second.
Simon, can I have a question about that?
Yes.
Okay, if the owner, okay, can be accepted the Section 8 application and then later on is not like he accepts someone else, he should provide information why he didn't accept the Section 8?
No, so you don't have to go into the initial reason, right? So
Okay.
the less you say, the better, right? Now, if someone is inquiring and asking a lot of questions, then you
Mm.
got to be mindful. They're probably trying to set you on a trap, right?
Yes,
So
right.
be very careful, because if they're asking very specific questions, then that should be an alert for you, right? That something doesn't feel right. It's kind of a little something in your tummy that says, you know what? I don't know. And at that point, it says, look, that's a great question. I don't have the answer. Let me get back to you. Let me speak to my office. Let me speak to the broker, and then I will follow up. Let us know, and then we
Mm.
will help you, guide you, and take you to the next step. I've been in a
Okay.
situation similar where a person who was a tenant didn't have any credentials in California. Everything was Canadian. Okay. His license, his bank information, everything was Canadian, but the guy lived here in California for 5 years. Okay. So that's kind of like, something is kind of off here, right? So asking the right questions. Well, the guy felt that he was being discriminated by one of our agents, and the agent was navigating the most practical way, but it's like, hey, you're not providing. I says it's not about what you say; it's what you put in writing. So she immediately reached out, Simon, I don't feel comfortable with this guy. This guy is already feeling like he's going to threaten and trying to sue because of discrimination. I need your assistance. I says, not a problem. So I reached out, talked to the attendant, and yeah, he was very frustrated. Why is it that I'm not getting the unit or the property? I've provided everything necessary, and I feel that I should qualify for this, right? So I navigated as like, I appreciate it. I wanted to kind of get your side of the story. I will be sending you an email once I speak with the housing provider so I can get a better understanding of what their qualifications and criteria that they're looking for, right? So then I did my little bit of research, got through the elements, and then I says, well, someone that lives in California as a resident has to immediately get a California driver's license or California ID. So that's one. Two, bank. Why doesn't he not have a bank here in the US, right? So that was another thing. Please provide me with some type of information from an institute, here in the U.S., not California, here in the U.S., right? And then three is that that because he didn't have a Social Security, right? So how do we check his background, right? Well, there's a site that allows for people outside of the U.S. to still get a copy of their credit report for their state. Okay, and I was able to find a website in the in Canada that allows them to run their own credit criteria through them, right? So they would provide me with a credit report, right? Because if you don't have a physical Social Security, we cannot run any credit. But remember, credit, like your Visa, MasterCard, American Express, Discover, and any other credit cards, is worldwide. It's not just the US, right? So there has to be some type of system that we can, vent and see their qualifications, right? So I provided a list of all of these list of checklists that we were requesting. Never heard from the guy ever since, because he was probably a type of guy that was going to use a entity that it wasn't even him, and he wanted to compromise and live in a place and then probably stop making rent. They don't care if they stop and they go through the eviction. It's not impacting my personal stuff. He might have had a Social Security, he might have had a bank account, but he was using his Canadian credentials to qualify for a tenancy. And the problem is, we don't know how many times this individual has been doing it and got away. He could be a repeated offender, constantly being evicted because someone took it for face value and thought, well, the guy seems like he was a super nice guy, very nice guy, but we don't know the history and his background, right? And that's what the situation. But after I send that email, I never heard back from him, and problem solved. We are fair housing providers, and all qualified applicants are welcome. This is the recommended response whether a prospect tenant asks if Section 8 or housing vouchers are accepted. Memorize it, train your staff to use it, right? Again, we accept all applications. Just, common sense, folks. If anyone says, hey, do you accept Section 8 vouchers? What's your answer?
Yes.
Yeah, we accept all applications. Please submit. Keep it simple, keep it short. Because one, they're not going to have any additional questions to entrap you. And that might be where they're not going to submit an application. They're trying to catch you in a process of entrapment. Because then the follow-up is, what's your name, what's your company, give me your information, and now you get a slap with a lawsuit. Like Simon, I received this lawsuit from this company or a attorney or firm about this individual that I remember having a brief 1-minute conversation. It's happened twice in our office here. Okay. And it's a common thing, folks. So be mindful and be very careful. All right, now let's go into part 2 of it, how to properly evaluate an application involving a housing voucher, right? So here is kind of the venting process, right? Now, for me, I personally do not take on any listings that are housing for rental. I just won't do it, It's just too much paperwork for very little income. It's not worth my time, effort, or energy. So I'll delegate it to someone. It's far and few that I get, but I'd rather get someone else involved and let them finish it off, right? It is some sort of income, but it's really very minimal income, right? So if you can avoid it and focus on the big money, which is transactions and sales, that's the direction that I would go. I hold this clicker in hopes that it will click, and it never clicks. So not sure what's going on. All right, conduct the public housing authority immediately. Contact PHA. And this is, again, just for your sake as educational aspect, not that you're going to do all this, right? But, it'll give you a guidance if you're going to go in a direction that maybe your clients is okay to allow Section 8, right? So it's something that you can do a little bit of research, provide the housing provider in the right directions to qualify, because there is a process. Okay. So the housing providers are not already approved by the local PHA. Contact them immediately upon receiving an application for a voucher holder, working collaborations with PHA to understand and fulfill their participation requirements. Some processing delays are expected. Unreasonable delays caused solely by the PHA are not applicable, may in some circumstance justify the proceeding with that specific applications, right? So again, if your clients are okay going in that direction, there is an initial process that they must go through. Apply income standards to the tenant's portion only, right? The rule when applying an income to racial income qualification standards, you must base the standard only in the tenant's share of their rent, not the full contact rent. The subsidized portion paid by the government is not the tenant's financial responsibility and cannot be factored into your income screening. For example, if a monthly rent is $3,000 and the tenant voucher covers $2,000, your income standard must be applied only to the tenant's $1,000 share. Okay. Why does this matter? Applying a state standard income multiplier three times the rent to the full 3,000 will effectively screen out the voucher holder, right? And this goes to your question, right? So you base it on, their actual amount, okay? And if that actual amount, then it changes the trajectory, which constitute the source of income discrimination, right? Collaborating the standard to the tenant's 1,000 portion is both legally required and practically fair, okay? So keep that in mind. It's their portion. Step 3, credit history. Applicants may opt out. The applicant's right. A voucher holder applicant has the legal right to prohibit the housing provider from pulling or using a credit history report as part of the screening process. Okay. So not just that alone is a good way to say, well, this and that, right? It goes into the details of this. Alternative screening. If an applicant opts out of credit screening, you may require alternative verification evidence of their ability to pay their portion of rent, such as a bank statement, pay stubs, or benefit award letter, right? Such as Social Security. Maybe it's a retired person, or they're up in age and they're collecting Social Security or some type of pension, right? So there's other avenues that you may use as well as part of the venting process. Consistency and key, right? Whether alternative screening criteria you use, apply them as consistently and fairly to all applicants who opt out of credit history check to avoid appearance of differential treatment, right? So I understand. Look, the way you navigate this, will alter, right? Most housing providers will want part of the checklist is a credit history, right? We want to see their credit. We want to see their FICO scores, right? Because think about it for a quick minute, right? Would they be able to go and buy a vehicle or get a credit card, right? Well, they're probably going to reject them or decline them, right? Because their credit is very low or they have bad credit, right? That also goes in the avenue of how this may also navigate when it comes to an applicant applying for a rental space, right? A house or apartment or, a condo or a townhome, right? And maybe the housing provider is okay with this, because I've seen circumstances where the housing provider is, I can care less about their application, credit, right? They're good people. I know them. I've been to them. I understand, and that may be okay. Remember, at the end, it's the housing provider's decision. Okay. I'll be the first to admit I allowed someone that was literally homeless, living in his vehicle. Yes, he had a job. He was a truck driver. But I found out not from him, but indirectly from a source that was asking, "Hey, Simon, do you have anywhere that I you can rent for this individual?" We're really saddened about the circumstances. He's a really nice guy, hard worker. So when I met with the guy, there was something in my heart that just says, this guy is really good, and I took it for face value. He was one of my best tenants, believe it or not. And to this day, he no longer he has his own place. Was able to get on his feet, was able to rent his own place. He was able to pay off his car, and he was able to get a promotion. And yeah, it's just one of those situations that sometimes it's not what's on paper, it's really the interaction with someone, right? And I took a risk with him, right? Because I mean, didn't have a place. He lived homeless. He lived in his vehicle, right? But everything else aligned with me, and I was okay with it. So again, we all been in circumstances, right? And sometimes it's important for us to even meet with the people too as well, so we know who it is, not always just over the phone, via text or via email. Sometimes we need to meet with the person because that'll tell us a lot about the individual, right? So keep that in mind, especially if you have your own investment properties. Equal treatment doesn't end at move-in, right? Fair housing obligations continue throughout the entire tenancy. Vouchers holders, tenants must receive the same quality of service, access to amenities, and lease terms as any other residents, right? So you don't treat them any different because they have some type of assistance, right? You treat everyone equally, right? Just like us, right? We like to be treated well, right? Like when we go to a restaurant and you have a bad waiter or someone that's a little rude, right? We take it personal, right? Well, that's kind of the same way too. Just because they're in this circumstances because of low income doesn't necessarily mean they're bad people. Okay. They may be going through a bad situation, right? A lot of it is separations where, a married couple with kids, now they're going through a separation and a divorce. The income is not there, but, she and the kids need to have a place, and they just rely deeply and heavily with the husband, right? That might be a circumstances, right? Or even a male, right? They may be uh, in between jobs too, as well, and a good person. So you got to look at it from face value as well. Equal service and amenity access, right? Timely repairs and maintenance. So again, kind of all the standards, right? Once your client um, has a qualified tenant, our job is done. As soon as the lease agreement, exchange of monetary, the deposit, first rent, your commissions, we're done. We're done with the process, right? We've completed our fiduciary duties, and now it's really up to them. So any issues that the tenant has to directly to the housing provider. Any issues that the housing provider has to directly to the tenant. We're done. We're not involved in the property management or the back and forth, even though they're going to rely on us, right? You just need to tell them, I'm sorry, but my job was done as soon as we got the signed lease agreement and everything was finalized, right? So keep in mind. So just because you have a voucher client, right, a Section 8, no extra charges. Okay. What is prohibited? Charging higher rent to a Section 8 tenant than to comparable non-voucher tenants, require a larger security deposit based on voucher status, imposing additional fees, charges, or conditions solely because a tenant is using subsidy, right? The principle of charging more in any form to a tenant because they receive government housing assistance is a direct violation of source of income protection. All financial terms must be applied uniformly, regardless of how rent is funded. The fact that the portion of the rent comes from the government does not justify any financial differences. So, no termination or non-renew based on voucher status. Okay, so keep this in mind. It is unlawful to terminate a tenancy or refuse to renew a lease simply because a tenant becomes eligible for or begins receiving government housing. So let's say that the person goes in, had a great job, and then during the process of renewing, they're saying they're part of Section 8, but they're in the property. Okay, question?
It's not happening because there's like what 10 years wait list.
Yeah.
Not something that you know happens during it.
It's very far and few, absolutely. But what if this person has gone through the process 5 years ago and now qualifies, but you have already allowed this person to move in? Well, the housing provider cannot and should not say, oh, by the way, no, we don't accept Section 8. I rented the place to you as someone that had the income, right? So in this case, you cannot discriminate and say we're not going to renew your lease because now you're collecting Section 8. No, you have to continue. You have to allow them not to want to renew, but you as a housing provider, meaning your clients, cannot just change and say nope, we're not going to do so, right? Okay, so be mindful of that. Again, this is something that you're not going to be involved in the process, but it's good to know in case you get some type of question. All right, who can be held liable, right? Fair housing liability is not limited to just the property owners. Multiple parties in the rental transaction chain can face legal exposure for discriminatory acts. Okay, so be careful. Remember, they can drag us into a potential lawsuit, and that's what we're trying to avoid, right? So liability extends throughout the chain, right? So property owners, co-owners and partners, property managers or agents, brokerage and firms, right? So these are all of the different people that are exposed, right? Even though, Simon, I didn't do anything, but because you were part of the process, you might be entangled in this scenario. Okay. So the beautiful thing is that the contracts has specific language that allows us to explain that we're not a party to this. Okay. We initiate the paperwork to find a qualified tenant, but at the end, it's between the tenant and the housing provider. And there's language on the agreements that takes us out of the equation. Even though someone will drag us into a potential lawsuit, our position is that the seller, or excuse me, the housing provider takes full responsibility of the entirety. I'll give you an example. Many years ago, we had a situation where a tenant got injured on the property. It happened just like a month or 2 months after the execution of the lease agreement. I don't remember. It was an uneven pavement. Guy ended up tripping, hit his head, and ultimately got medical attention, lost the wedges, lost his job, then sued everyone. And he dragged the agent because the agent was the agent involved in the transaction, even though the agent had nothing to do with the fall, and the unfortunate situation, yeah, there was an uneven pavement. I guess there was a large tree, and it cracked the concrete sidewalk in the backyard. So now the concrete, instead of being even because of the roots, exposed it. And sometime in the late afternoon or evening, the guy tripped, lost his balance, hit his head. Okay, that's the claim, right? So because of all that, that started a chain reaction of hiring an attorney, suing, the housing provider for that, right? And thank goodness, part of the initial process, it does say is that the housing provider would take full responsibility. One, get their homeowners insurance, and there's language again on the agreement. So when they try to bring us into this potential lawsuit, we uh, we got something in writing from the housing provider that the housing provider would take full responsibility. So that was our exit. And because of that, we got our attorneys to send a letter to the tenant's attorney saying, based on the lease agreement and documentation, we're pulling out, housing providers taking full responsibility. And he allowed us to back out of the situation. And then it was just between the tenant and the housing provider. And ultimately, the housing provider's insurance, right? Property insurance ended up paying, I don't remember what the amount, I think it was like $40,000. $40,000 is still a lot of money. Okay. So, and we don't know the severity of the situation, right? So be mindful of that because it could happen. Okay. All right. So apply standards in the tenant portion. I think we talked about that. All right. Did we talk about all this? Yeah. I don't know why. Liable. Okay. So for some reason it put me back. Here we are. Okay, so agents cannot hide behind owners' instructions, right? So agents and property managers, if any owner instructions you to refuse Section 8 applicants or treat vouchers holder differently, follow the instructions exposing you personally to a fair housing liability. In addition, the addition to the owner, you have both a professional and legal obligation to refuse discriminatory instruction, right? So again, California law holds agents to co-owners and brokerages and independent accountable. A real estate professional who carries out a discriminatory directive, regardless of who used it, can face civil right complaints, damages, awards, and license consequences. When in doubt, consult with your broker or with the car legal team, right? So as part of your association with the National Association, the California Association, we have what's called a legal hotline where you as a real estate agent can call the legal team at CAR any given time and ask for guidance and support, right? Now, I also want to be mindful of this is because remember, CAR is also attached to NAR. Okay, CAR is also attached to NAR and DERE, right? The Department of Real Estate, right? Be mindful and careful when reaching out to CAR asking for some guidance because they're going to want to know the initial issue, right? And if you say anything that compromises, they also have a right and obligation to report any issues that you brought to the table to the Department of Real Estate. That's why before you do so, reach out to us. We're going to protect you and we're going to say, wait a minute, this doesn't look right. Let's kind of backtrack this, right? Because the moment that you send it to legal hotline, they record everything. Everything is in their system. And they can use that against you if there's ever a complaint. And because they're connected in some way or shape or form, they can use that information against you. And that may compromise your real estate license. So be mindful about that too. All right, number 5, compliance checklist. Quick reference, are you in compliance, right? Advertisements and inquiries. Remove any no Section 8 language from all listings and advertisements. Remove any imply language, right, for professional owners, which again, we talked about. train everyone. This is why you come to these classes, to better educate yourself, right? Application and screening, contact your local PHA promptly, apply income. And again, this is more for your property owners. But again, it's mindful and it's great information to have. So you have kind of an understanding of what that looks like, right? Tenants compliance checklist, equal service for all tenants, no extra fees, equal amenity access. Again, just kind of the common sense. Everyone is treated equally, right? Building a culture of fair housing compliance, right? So the next part of it is avoiding a violation. No one wants to be involved in any situation, right? So practical steps to reduce the exposure, right? Written screening criteria is maintain written, consistent, applied tenant screening criteria that implicitly reflect fair housing compliance, including how income is calculated for voucher applications, right? Which we already explained. It's not the entire, it's based on just the individual tenant's income and how you calculate based on that. Training, right? So coming into the classes is vital and important, asking the right questions. We're all here to support you. Audit your listing, right? Review all online listings. Again, if you have third-party people that are helping you, make sure that you're approving it before it gets syndicated, because once it's exposed, it's open to everyone, and someone may see that and send it to the proper channels and authority, and now you're getting a letter or an email or a call saying, "Hey, we want to talk to you about this information that you marketed," right? And then document everything, how vital and important. We all need to make sure that we're real estate professionals, and part of our initial process is not what we say, it's what's in writing. So make sure that anything, and if everything feels a little bit uncomfortable, maybe moving forward, you want to put everything in writing, and it's okay to ask, the tenant or the housing provider, hey, you know what, moving forward, I like to just have paper trail of our conversations and the process. So you and I are not missing anything. Please make sure to put things in writing. Okay. That way you can put everything together. And if this goes sideways, there's your defense right here, right? Because I'm telling you, you're not going to remember anything and everything that you said a year ago, 6 months ago, right? When this deal closed and now someone is coming after you. But you'll definitely remember, it's like, oh, yes, I do remember having this conversation because I saved the text, I saved the email. This happened on February of 2025 at 1:42 p.m. This is what was said, right? So keep that in mind. Everything should be documented. That'll protect everyone. Your takeaways: source of income is a protected class. Enforcement in active and aggressive. Adjust your screenings. Stay consistent. And again, the liability of the situation, right? So here's the last part of the presentation. And it really just goes for more information and legal guidance. You can always call the CAR Legal, right? And speak directly with the California Association of Realtors attorney for guidance in fair housing compliance in Section 8. Obligations, our phone number is 213-739-8282. Now, you can only use the legal hotline if you're a member of the California Association of Realtors. If you're not part of the association, then unfortunately, you're not going to be able to speak with them. Then you speak with internally with us. Okay. Also, we have some reference documents that if you want, this is the Q&A. You can download it as well, the mandatory Section 8 and source of income discrimination and Section 8 housing voucher program. So when you click on it, let's see, it's going to provide you, again, right from the California Association of Realtors, all of the information. And what I love about this, it provides you with Q&A, right? What is the law regarding source of income protection, right? And then it gives you the answer. What type of housing subsidy programs are included under the source of income protection, right? And there's just a list of different things that you can use to reference, right? And you can also submit this as well to your clients, right? Because this is all public information straight out of the California Association of Realtors, right? And here's a table of content. I mean, it's 20 pages of just information and Q&A that, it's good to have, especially if you do a lot of renting or if you represent tenants, how to maneuver the conversation and what's the do's and don'ts when it comes to that. Okay. With that, do we have any questions? I know I threw a lot at you. Okay, so what must present all offers? You say three, rent and the income. So the answer is yes, it really depends on the circumstances when it comes to 3 times of rent or rent, because that's kind of the standard, right? I personally would not say, you must qualify, because that let's say that the rent is $5,000 a month, right? That means if you say 5,000, that's $15,000, right? 3 times of that's 15. Does that mean that the tenant has to have income of $15,000, right? So you got to be very, very careful on how you maneuver and navigate this conversation, right? Take it for face value. My position would be is, if they're a strong applicant, you know, have them provide you with a list of everything, right? Because one, we got to look at the bank statements, right? Do they have the means to maintain, right? What type of work do they do, right? Because that also will tell you, their income sources, right? Because let's say that it's a teacher, right, that wants to rent a place, or it's a captain with Delta Airlines, right? You know that a captain makes substantial more money in income, right? So it's kind of common sense is that based on all that information, not that you're going to say, oh, we can't rent it to you because you're a teacher. That's not what I'm saying. What I'm saying is most people are educated enough to know the differences of different types of careers and based on all of the information that comes to the table. Again, at the end, it's not our decision, right? It's the housing provider's decision. They may go with the person that has the less income. They just believe that this person is a person that they want to rent. Who are we to say no to that, right? We only provide information and the housing provider will ultimately make the final decision. Okay. I hope that kind of answers your question. All right. Well, that concludes today's contract class. Surprisingly, right on time today. So thank you so much for being on today's class. And we have our next contract class next Friday, same time, here at the training room. So thanks, everyone. Enjoy your
Thank
weekend.
you.
And happy,
All right. Thanks, Simon.
happy June.
June Glue.
Thank you so much.
Thanks, Simon.
Thank you.